The Supreme Court is set to revisit a landmark voting rights case that could redefine how race is considered in American elections. At its heart, whether protecting minority voters can still be done under the 1965 Voting Rights Act, or if courts will strike down one of its last major safeguards. The group Fair Fight Action connects this to Section 2 of the Voting Rights Act, the law preventing racial discriminatory voting mapping. They say up to 30% of Congressional Black Caucus and 11% of the Hispanic Caucus could lose their seats if Section 2 is overturned. Fair Fight projects Republicans could gain up to 27 additional House seats if the case comes down in their favor. Georgia has joined the case as part of the multi-state America's brief that was submitted, stating compelling states to sort their people by race under the thumb of a federal court creates a perpetual lose-lose situation for legislative decision making. Here now to dive a little bit deeper into this case is Lauren Groh-Wargo. She's the CEO of the rights organization Fair Fight Action and former campaign manager for Stacey Abrams' run for governor. All right, Lauren, welcome to the show again.
Hello, thanks for having me.
All right, glad you're with us this morning. As we just said, the case is out of Louisiana that we were just talking about, but there's a lot on the line here in Georgia as well. Tell us what's at stake.
Yeah, so we recently did an analysis with Black Voters Matter Fund on the larger stakes of this case. So yes, this is a voting rights case that came out of Louisiana, where some non-African American voters, that's how they refer to themselves, challenged the addition of a new Black opportunity district in Congress. And this is a really radical new theory that they're challenging the opportunity for Black Louisiana voters to elect a candidate of their choice, saying that that is racial discrimination, sort of turning the argument on its head. And so we should back up, as your entry point made. The Voting Rights Act that was passed in the 1960s was about Black voters' representation and minority voters having the opportunity to fairly elect a candidate of their choice and not deal with lack of representation. So in 1963, before the Voting Rights Act was passed, there were just 4 Black members in Congress. Today, there are about 55. And in a state like Louisiana, where about 1/3 of voters are Black, similarly in Georgia, the argument has been there should be a somewhat commensurate amount of opportunities for Black voters to elect candidates of their choice, and Black candidates specifically. The case today is a rehearing. The Roberts Court is asking a pretty radical question. They already heard this case last session. They're coming back, asking them to really dig into this sort of reverse discrimination, radical argument. And the court is signaling, the way this has been teed up, that they are prepared to gut Section 2, which they've been on a multi-decade tear to gut the Voting Rights Act and really remake elections. So that's sort of the what's at stake, not just for Louisiana, but would impact the entire country, and not just Congress, state legislatures, and local races.
Yeah, you heard the conservative argument there saying that any use of race in redistricting, even to fix discrimination, violates the Constitution. How do you respond to that claim?
That is a radical theory. This is about voters having the opportunity to have accountable representation. Our analysis shows that if you gut Black voter representation in Mississippi, which is 40% African American, you redraw the map to have 0 Black voter opportunity districts, that is a complete remake of Congress. And that is not fairness. That is not accountability. That is a Republican power grab. And so we looked at the real life implications of gutting the Voting Rights Act, combined with this mid-decade power grab gerrymandering that Trump has mandated that Texas and other states do, could ultimately result, if the Roberts Court guts the VRA, in 27 new Republican seats, which would mean one-party rule of Congress. This is a radical, extreme, anti-fairness, anti-freedom initiative that is part of dismantling our civil rights in this country and would really gut the opportunity for people of color and other minorities to have a representative of their choice. So this is really, really concerning and could result in a scramble to redraw the maps in time for 2026. We know this is a far-right Republican priority because they've said it is. We have Steve Bannon and far-right folks in Trump world talking about how they don't have to win new hearts and minds, they just need to rig the maps, right? That was what they were talking about last year. So we're encouraging folks to get involved, to call their members of Congress, to advocate to reform the court and to pass a new Voting Rights Act so that we don't go backwards in time, back to Jim Crow, when American minorities and voters of color did not have representation in Congress. So this is very, very serious, and we're hoping folks will get involved and not let the court let the southern voters go quietly into the night here. So it's going to be a very big day at the Supreme Court today, the argument, and we'll be doing organizing with Black Voters Matter and other groups as we go forward in the coming weeks.
Lauren, I got a quick 30 seconds here left. I want to know that if you could speak directly to justices about this issue before they rule it, what would you say to them?
We need fairness in this country. Black voters are 85% of Black voters live in the South, and all voters should have the opportunity to have fair maps to elect representatives that will advocate for their issues. We do not want to go back in time to a Jim Crow era where Black voters do not have the opportunity to elect their candidates of choice, and all Americans do not get the benefit of a real diverse representative Congress.
Gotcha. Lauren, thanks so much for joining us. Thanks so much for your insight. Really appreciate it.